Yes, Mr. Medley Gardner, we've got to proposition 5.
Yes, thank you. Thank you. The fifth proposition is really the application of the test to the facts in Manai by Lord Steyn. The reason why it's an important proposition also for my purposes is that it shows that potentially very serious errors in a notice can be corrected by the Manai process. Where my learned friends and my submissions, I think, part company, is that my learned friend's submission is that there are some mistakes which simply cannot be fixed by Manai, whereas in my respectful submission, that is not how one delineates the borderlands of Manai. Manai, in fact, cannot... the type of mistake is immaterial to Manai. What matters is whether or not a reasonable recipient, how the matter would have struck the reasonable recipient, and if the reasonable recipient would be in no doubt as to what was meant, or no reasonable doubt as to what was meant by the defective document. The type of mistake is not relevant. And so in Manai, for instance, as we've already said, discussed, the nature of the mistake in that case was as fundamental, if one likes, as a misnaming. It was the wrong date on which the break notice was to expire.
Well, you say that the test is satisfied if the reasonable respondent was in no doubt about what was meant by the notice.
Yes, so that's not a felicitous expression of the test, I'm sorry, as to how it's...
That's not the same as asking what the giver of the notice intended to do.
Yes, I think that's right. That must be right. That is one looks at it from the point of view of the recipient, and what was intended to be done as a matter of psychological fact by the giver of the notice is neither here nor there under the Manai test. And so we have instances of the test operating to correct dates, that's Caradine and Manai. We have instances of the test, or an early iteration of the test, operating to correct misidentified premises, that's Cox and Sykes.
Well, you say misidentified premises. Misnamed premises.
Misnamed premises.
There wasn't any premises.
No, misnomers, but misnomers of a more than non-trivial kind for the operation of the notice.
Oh, it's a very brief report, but it seems to have been regarded as potentially significant that there weren't any premises called the Waterman's Arms in the relevant vicinity.
Yes.
If there had been, then one might have been left in doubt as to which premises the landlord had in mind, whether he made a mistake as to the premises or a mistake as to the identity of a tenant.
Yes, my lord, I think that's right. And the reason why I suggest that assists me in my case is, of course, there is only one possible repository in actuality of this tenancy in the real world. There is only one current and one ex-tenant. Well, there's only one current tenant who's capable of identification. And we do have, my lords, examples in the bundle of a third type of mistake that does give way to Manai-type correction in terms of misnaming. So there's one example which my Lord Justice Lewison provided us with this morning, which is the Lazarus Estates and Beasley case, in which, having reviewed the authority over lunch and adjournment, it was an instance in which a notice, as your lordships know, was given to was given to the correct tenant, but misidentifying the name as the name of her deceased husband. And the Court of Appeal decided in that case that, given that there was an identification of the recipient also as the tenant in that document, the recipient of that notice could have been in no doubt as to the fact that the addressee of the notice was meant to be the tenant, notwithstanding the name used. And that, I would suggest, is in line with the sort of factual situation that we've got here. Yes, a name has been used, but when one looks at the notice, one is also has one's attention drawn to the fact that it is given to the tenant, who is currently the tenant under the relevant tenancy.
So you say, do you, there is a contradiction in the notice between two Owen Gwilym Thomas on the one hand, and which you hold of me as tenant on the other. The notice was in fact served on the company, validly served on the company, and this is a false of demonstratio type case where one part of the notice is correct, namely you hold of me as tenant, and the other part is not, namely Owen Gwilym Thomas, and the reasonable recipient of the notice, viz. The company, would realise that it was intended.
Yes, I would say that if one imbues the reasonable recipient with the characteristics that I suggest Lord Steyne requires us to imbue him with, he will look at that notice and know that the addressee of that notice is the person capable of complying with the notice to quit and delivering up possession. That is the intended addressee of that notice, or that is how he would take it. There is another case about misnomer in the bundle. It's actually about, I think, two facets of misnomer. It's behind tab 9, and it's the Harman Properties and Gajdi's case. And the facts on which it is relied upon is that the notice was given to, I may not get this the right way round, but the addressee of the notice was described as Vladislaw, not Walter.
The other way around.
The other way around, Walter, not Vladislaw. I thought I'd make a mess of that. And the court decided that was an innocuous misnaming error. But the court also considered the impact of the fact that there had been a misidentification of the landlord. And we find that at 1864 between B and F. And if I could just invite your lordships, your ladyship, to look at the 1864, that's page 82 of the bundle, between B and F. If I attach to that the observation of the Vice-Chancellor McGarry in the Townsend case that it's quite difficult to see a distinction between giving and receiving in terms of the identification, I pray that passage in aid as being a further supporting plank to my submission that the misnomer in this case is innocuous and curable, and this is another instance in which the court regarded it as perfectly obvious that a tenant in receipt of a document which can do one thing and one thing only, that tenant would obviously assume that that document was emanating from its landlord, no matter what the technical infelicity of the document might have been. So, in my respectful submission, where I disagree with my learned friend's submission is that it is wrong to conceive of Manai as identifying categories of error that are curable and categories of error that are not curable. What matters is how that error would strike the reasonable recipient, irrespective of the nature of the error, how it would strike the reasonable recipient in the relevant context, and whether that reasonable recipient would know what the, as it were, the correct meaning would be. And so I say that this case can rattle through all 5 of Lord Steyne's propositions and comes out in the same position as the facts of Manai did. There's no doubt as to what the notice was meant to do that could reasonably have been harboured by its recipient.
Well, you slid again from what does the notice mean to what was the notice meant to do?
Yes, sorry. No, but again, as I say, those 5 propositions I say lead one to the same to the conclusion that the respondent is contending for. I would, if I may, like to then move on from Manai, pausing only briefly to note Lord Hoffman's observation, Lord Staines's observation later on in the judgment, that one is seeking to avoid adventitious taking advantage of innocuous errors by this mechanism, to then look at the authorities which are before the court. And I'd just like to say a few general things about the authorities. The first point is that Manai, of course, is sensitive to the particular context of each case in two very material respects. The first is that one has to have regard to the nature of the notice that one is looking at, by which I mean not that whether it's a break notice or a notice to quit, but rather the legal rules that inform what the notice should look like. At one extreme, one has what my Lord Justice Lewison referred to earlier as the pink paper, blue paper type clause, which is highly prescriptive and says this key and only this key fits the lock. At the other end, one might have a clause which can simply be complied with by providing very general words. For example, what could have been done in Manai itself, simply saying 6 months, this clause break, without sticking one's neck out and sticking a specific date in the document. And in my respectful submission, building on the Townsend case and building on what I've referred to earlier, the common law rules relating to the notice to quit are very much at that more general end of the spectrum. There is no statutory overlay prescribing information in this case, like there would be for a residential premises, for example. The common law rules suffice, and the common law rules certainly contemplate that a simple generic identification of whoever the tenant is sufficient. And in my submission, Townsend provides support for the proposition that it may go even further than that, and that there is no need to identify either as an abstract class or a specific person the tenant at all, provided that the notice gets to them and lands on their doorstep. Now, in this case, that's one material background fact, which of course the court has to be aware of. What did the statute or the contract require for compliance? What was the purpose behind that? And the second category, of course, is that each case, as your lordships and your ladyship would expect me to say, rather turns on its own context. So the context in Morris is not the same as the factual context in this case, and one cannot, I respectfully submit, extract a general principle, for example, from Morris, that a misnomer is never curable. All one can extract from Morris is that the misnomer was not curable on the facts of Morris in the context of that case. And I'll come to the material context that I say is relevant to Morris in a moment. Now, there are some cases which are suggested to be misnomer-type cases where there is no cure in the bundle, to which reference has already been made. And examples of that would be the Old Grovebury case, the Jones case, the Prudential case, and possibly also Standard Life. In all of those cases, it's been suggested that those are instances of the courts not being willing to cure misnomers. But I'd respectfully suggest that those four cases are not instances of misnomer properly so called.
But Old Grovebury has nothing to do with misnomer.
No, well,
the document was served on the wrong person.
Precisely. They're not misnomers. They are just simply cases where either the notice has landed on the wrong person entirely, or it hasn't landed on enough of them, because it's only been given by one of two joint tenants, for example. Cases of that nature. Those aren't...
Well, Jones was a case where there was a statutory requirement to serve the tenant. Yes. The tenant was two people, and only one was served.
Yes, exactly. And
only one was named.
Only one was named. And Prudential was a case in which, I believe it was a contractual notice case, Prudential, and only one of the relevant contracting parties was served, and the court decided it couldn't be clear whether that had been a deliberate choice or not, that only one had been served. But I'd put those cases to one side as not illuminating our problem, because those cases, as your lordship observes, are not about mislabeling a notice which has gone to all the right people. Those are cases about notices that haven't gone to all the right people. So they
come to a point. I mean, in Morris, the notice did go to Mr. Fry, who was the right person to receive it.
Yes, and I'll have to tackle Morris because that is obviously it's either the light at the end of the tunnel for my learned friend or the 1039 for Euston for me, depending on how we deal with it. So those cases, I think, in my respectful submission, need to put to one side. In my respectful submission, also to be put to one side are the two Scottish decisions. Obviously, my learned friends correctly point out those are persuasive rather than binding authorities. I won't address you on that because that's a matter on which your lordships and your ladyship will take a view. But in my respectful submission, it is important to understand what the basis of those decisions was. And I've already addressed that in part in opening, but I'd like to take the court to those judgments.
Before we do that, can I go back to this question of the persuasive nature of the decision of the inner house?
Yes.
Because Mr. Jordan's submission was, unless it's a bit of law where Scots law differs from English law, we ought to follow a decision of the inner house unless convinced it's wrong. Do you take issue with that formulation of principles? I have to say, speaking for myself, it's not a problem I'm particularly familiar with.
It's not a problem I'm particularly familiar with either, except that from a position of judicial comity, one might expect that if there is no reason to doubt the correctness of a decision, it ought to be followed. However, as with all of these cases, there will be areas of local practice, local law, that might be relevantly different. So, it being a mixed legal system, there might be a different attitude taken to the construction of documents, and adjustments need to be taken for all of that. But for the reasons I'm coming to, I think that it's not so much a question of deciding whether or not, as a matter of judicial comity, one should follow those decisions, but rather looking at those decisions. In my submission, they don't tackle the question which we are being required to tackle in this appeal. So if I can duck the question by saying the point doesn't arise in this case. And the reason I say that is for the reason already identified this morning, which is that both of these cases are not about seeing whether Manai can cure a defect on the face of the notice, because both of these cases stopped short of Manai. Both of these cases decided on their own facts that there was a service problem. In the Ben Cluch case, on the basis of a contractual break option which was operated, and in the Belgrave case, on the basis of a notice in writing that needn't have been in writing under the Agricultural Holdings Scotland Act 2003. So the context of Ben Cluch is of a contractual break option. And as you will see from the judgment that when my learned friend took you through it, the court obviously had regard to the contractual conditions that it regarded applied to the valid exercise of the notice. And I'd just like to draw the court's attention to two short paragraphs, if I may, knowing that you've already obviously had an opportunity to look at it. It's paragraph 59. It's page 267 of the report and page 46 at the bottom of the bundle behind tab 3. And the question that that is being asked here is one about the giving of the notice rather than what it says. In our opinion, the Lord Ordinary reached the correct conclusion on this aspect of the case of the break notice sent to Bonnytoon at its registered office was not given to the landlords of the premises and was therefore ineffective. And that is a subtle but, in my submission, very important distinction. That is the basis on which this case turned. It did not turn on the misnomer in the notice. This case decided that the notice should be treated as never having landed on the correct doorstep at all. That isn't an issue in this appeal. We are one step on looking at the Manai situation and bearing in mind again the contractual nature of the notice that was given in Ben Cluche. And that becomes clearer still when one looks at paragraph 64, which my Lord Justice Lewison has already read out in court. Paragraph 64, nothing turns in this case on the construction of the notice. It was invalid because it was not given to the landlord, but to a third party. The stage of considering how the notice would be understood by the recipient is not reached. So we are not, that case is not addressing our problem. Our problem is the notice having reached both the natural person and the legal person. How does the legal person interpret the notice? We are not at that stage. Even further removed from the present facts is the subsequent decision in Ballgray and Hodgson. And the reason why I say that is that if one goes to the report in Ballgray, which is at tab 2, you'll see at page 842, paragraph 12, by recorded delivery, letter dated 29th of May 2014, agents acting for the respondent purported to give notice under section 72(6). The notice was addressed not to Ballgray Limited nor to their registered office, but to Michael John Jardine Patterson, Ballgray, Lockerbie, Dumfriesshire. And that is not the registered address of Ballgray. So it landed on the wrong doorstep. And it's for that reason, again...
In Ben Cluche, it got to the right registered office.
Yes, one of them did.
Shared.
Yes.
Between the two companies.
Yes, but it was decided, I would suggest, on the clause in question, the contractual provision in question, that wasn't good service for the purposes of the contract.
But the reason it wasn't good service wasn't because it didn't end up in the right place, which it did, as my Lord's just said.
Yes.
The reason it wasn't good service is because it was addressed not to company A, but to company B.
Yes.
And the court says you can't say that a document addressed to company B, which happens to turn up at the registered office of company A, has been given to company A. That's because you've got to specify which company it is, and once you've specified company B, it's given to company B and not to company A. That's not about which postbox it's ended up in. It's about what does the document say, and what the document said is it's addressed to company B. So although it's analysed in terms of who is it given to,
yes,
the explanation as to who it's given to is exactly the same as the one that Mr. Jordan relies on here, is that the addressee on the face of a notice is B, not A. I mean, that is the same as here.
Except that I would submit respectfully that your Lordship has, in setting out those facts, identified the difference. The contract requires the notice, the court finds in that case, to be given to the landlord who is identified, to be identified in the notice. But here we're navigating the common law world where nobody needs, the common law rule where nobody needs to be identified.
Well, nobody needs to be identified, but I understood it to be common ground that at common law a notice to quit has to be given to the tenant. If you give a notice to quit to somebody else, it's of no effect at all. What the common law rule says is you don't need to actually put the tenant's name in as long as it's clear you're giving it to the tenant. So if you give it physically to the person who is your tenant and say this is for you, that's good enough. If you send it to the tenant at the premises, that's good enough because it has been given to the tenant. But if you, what the Scottish case says, but Ben Cluche, is that if you do put the name in, then that's the person you've given it to. Even if they share a registered office with another company with a different name, you can't say you've given it to the second company. And I don't find that very different from the facts of our case.
I think you see it most clearly at paragraph 60 of Ben Cluche, on page 46 of the bundle, where referring to Manai, the court says that Lord Clyde identified the requirement that the notice had to be served on the landlord or its solicitors. The dispute was whether what occurred constituted such suppliance. In our opinion, the dispute can be resolved very shortly. a notice addressed to a party other than the landlord and sent to the registered office of that other party cannot be regarded as a notice given to the landlord. So here, notice addressed to Mr. Thomas and sent to Mr. Thomas's home cannot be regarded as a notice given to the company. That would be how that translates onto the facts of our case.
Yes, my lord. But of course, then here we also have the statutory service provisions under. So if we're looking at service rather than the document says.
We're not. I mean, we're looking at to whom it is addressed.
Yes. We've certainly got. I see the logic of that point. Obviously, it says what it says, and however much I wish it didn't, it says that. But on the other hand, we do have the cases that I've referred your lordship to that show that in this jurisdiction there are cases, including the illustration that you presented us with this morning, that show that these misnomers are not fatal. And I do suggest that this case is focusing very much at the level of service of a contractual notice in contractual form with contractual requirements, which are not a feature of the common law notice to quit, which allows either generic identification or, if Townsend is right, doesn't require identification of any kind at all.
Well, Townsend's about a slightly different point. Townsend is about misaddressing it.
Yes.
I mean, I think it's common ground. Identification in the sense of naming the recipient is not required.
Yes.
But what happens if you name the wrong person? That's what we're concerned with.
But that's what then brings you into Manai, because that is not an abstract question. That is, in my submission, a concrete question that one answers, imbuing the reasonable recipient with all those things that it's permissible to imbue them with under Lord Stein Proposition 3, I think. It's a concrete question, and that's why I'm seeking, of course, will later on seek to duck the Morris decision, because I say that is a totally different factual constellation from mine, and doesn't bind this court. It's a different assessment of different factors. But I suppose the best that I can do on Ben Kluke and Ballgray is say that the issue that's in play in that case, in both of those cases, is not in play in this case. And it's not in play in this case, and can't, I say, be in play in this case, because our common law notice doesn't have the same requirements as either of those notices. Does not have the same requirements for validity as the Ben Kluke notice did. And that in this case too, of course, there are service provisions provided expressly by the AHA under Section 93, which expressly provide that a notice can be given to a company director or to the person with management and control of the everyday management of the agricultural business. And it is an agreed fact in this appeal, and has been an agreed fact below, that that person, and the only person that can be,
it's Mr. Thompson.
So that's what I have to say about that. Then one gets to a sort of so I say the Scottish cases are answering a different question in a different context that does not affect this appeal and the issue in this appeal. There are then other cases, some of which do, I have to accept, raise difficulties, which are relied upon by my learned friends, as again seeking to suggest that Manai doesn't reach all the parts that I would like it to reach. And those are cases which I respectfully would suggest are cases where, in fact, on a close analysis, one is dealing with what are probably best understood as non-compliance with statutory requirements. And there are three such cases that you have been referred to, and I'd respectfully suggest that one of them is Morris. Morris was a case not of a common law notice to quit, but of a prescribed form of notice under Part 1 of the Landlord and Tenant Act 1954. And one of the rubrics that needed to be filled out under the prescribed form of notice we see from the report you were taken, if you recall, to the part of the report, was that the tenant had to be named in it. And that was a prescribed form of notice. That case is not this case.
Can you show us? I didn't pick up what Section 4 of the 54 Act says.
The actual prescribed form isn't in the bundle, but at 275. So this is the tab 19. I think it's around paragraph 5 of the report.
Well, at paragraph 3 on page 278, Lord Justice Mummery refers to notice being given to the tenant in the prescribed form. Nothing seems to turn on the prescribed form, because he says the short point is whether on the facts it was effectively given to the tenant. That's the issue that he describes.
Yes. And put in that way, it's not a Manai point at all, really.
No, but then Section 26 operates when a notice is given to the tenant, so it's the same phrase.
So what I would say about that, my lord, is that, again, one draws a distinction between Morris in this case. And I have to obviously distinguish Morris. And what I would say about Morris is that Morris is a case in which we do not know whether the tenant was aware that the landlord was aware of the assignment. In this case, we know that the tenant knew the landlord was not aware of the assignment. And that is a fact I suggest that makes all of the difference. Because in this case, what Lord Justice Mummery was concerned about was that the tenant, in this case, might either not open the envelope at all. So I should wind back. The points of distinction in this case, apart from it being a statutory notice, are also that in our case, the legal person and the natural person are, in practical intents and purposes, the same entity. The envelope would have been opened by the tenant as a natural person, or the tenant with his hat on as a company director. The problem of the returned to sender envelope does not arise on our facts. Whereas Lord Justice Mummery points out that on the facts of that case, although it's been argued on the assumed basis or the common ground that there was service, the parenthetic words "or the envelope" might suggest that one of the concerns playing in his mind was that it might simply have been returned to sender. This isn't my mail, I'm not going to open it. That is not a fact in this case. That would be the first point. The second point I would make is intended to be a respectful criticism of the reasoning in this case, which is that it might be an example of what Lord Stein described as conclusive reasoning, that it is not necessarily a case in which one can very easily follow why it was that Lord Justice Mummery reached the conclusion in that case that the tenant could safely put the notice into the bin. But the third point is also that there is a world of difference, I would suggest, between the hypothetical world that one would have to imagine in a Morris-type case and the hypothetical world one imagines in this case. The hypothetical world in the Morris case is of a tenant who receives a letter addressed to his predecessor in title who hasn't lived there for 16 years, who are two entirely separate human beings, and who sees a letter addressed to a person who has not lived there, as I say, for 16 years, whereas in my case, in this case, we have exactly the same person for all practical intents and purposes, being the assignor and the assignee. In fact, there is no other natural person who exists who could deal with this property on behalf of the corporate tenant. And that person knows that 3 days, not 16 years, but 3 days previously, an assignment has taken place in circumstances in which that person has been in control of both sides of the assignment process, and that person knows, as a fact, that the giver of the notice is wholly ignorant of the fact that
is that one of the agreed facts? Is that
it's agreed? Yes, it's an agreed fact that my client was wholly unaware of the fact of the assignment.
I haven't understood why it makes a difference whether it's 3 days or 16 years.
I suppose the only difference, my lord, might well be that the proximity of the parties and the proximity in time might make it more natural that one opens the envelope, if you see what I mean. Whereas a letter addressed to somebody who's not had a connection to the premises for 16 years might well not be something that excites the interest of the current tenant, might not be something that is opened up. But in my suggestion,
I mean, the problem with taking a point like that is it invites the question: how long is long enough?
Yes,
and that's a disastrous line to go down, because everybody, I think, agrees what one wants in this area of law is certainty.
Yes. But the point I'm trying to make, my lord, on it is that there are points of distinction, but the key point of distinction here is that in Morris you have two different natural persons without any connection with each other involved, the named person on the notice and the person who is the tenant, whereas in this case the hypothetical world allows us to imbue the recipient with the fact that he's not just the natural person who's named on the notice, but is also the sole guiding mind of the legal entity that is the tenant, as a matter of fact, coupled with knowledge of the fact that the landlord doesn't know of the existence, let alone the assignment to the legal entity. That's a totally different factual world, I would suggest, to Morris. So,
and you would take into account in the context, when one is looking at applying the objective test of the reasonable recipient, all of those matters, that there has been an assignment, it was only 3 days ago, that the landlord didn't know, or not?
I would, my lady. I've in the last 5 minutes become slightly less keen on the 3 days point.
But all of those you would wrap up into
yes.
relevant context.
Those Lord Steyne says we import. For example, one of the things we import is a knowledge of the terms of the lease. We're not dealing with a pure abstraction. We're dealing with how a reasonable person, which may of course be different from how the actual person reacts, but how the reasonable recipient responds imbued with permissible bits of knowledge. And
those you say are all permissible bits of knowledge.
They're all permissible and all not present in the Morris case, and therefore distinguishable. If I were being brave, I think the submission that one might make is that Morris might be a decision that could have been decided differently if analysed more closely, but that I'm not that brave for these purposes.
Well, if you look at paragraph 9, you can see Mr. Berry's submissions, which are very, very similar to yours, that a reasonable tenant would know that he was the tenant. Mr. Barmby wasn't the tenant. Can't think the notice was intended for Mr. Barmby, who'd ceased to be the tenant. And so it must have been intended to be whoever the actual tenant is. I mean, that's effectively the same argument as yours, with the difference that in our case, the tenant knows that the landlord doesn't know there's been an assignment.
Yes.
I understood Mr. Jordan to rely on that as identifying that the reasonable recipient in the place of a tenant knows that this is not a case of misnomer in the sense of I mean to address it to the company but I've got the name wrong, but knows that the mistake is that the landlord believes Mr. Thomas still to be the tenant. That's the very point he relies on.
Yes, and that's the generality point. At what point do you look at the mistake?
What sort of mistake counts? And that's your point. You say there's no. It's only this type of mistake that counts.
No, there's no hermetically sealed category of mani curable mistakes, and everything outside that is incurable. What matters is how the mistake plays in the hypothetical world with the reasonable recipient. And my respectful submission is that there is a distinction, for I need to draw a distinction between Morris and this case. And in Morris, the reason why Lord Justice Mummery in paragraph 11 says that the reaction of the reasonable tenant receiving a notice addressed to Mr. H.G. Barmby or receiving an envelope so addressed, the reason for the parentheses is that on the face of it, Mr. Fry would have no business opening an envelope addressed to Mr. Barmby, and one can't be confident that Mr. Fry would read that letter. Whereas in our case, that issue doesn't arise, because to all practical intents and purposes, the same human being who is the outgoing natural person who's the tenant also is the only earthly embodiment of the incoming legal person who's the tenant. So that issue doesn't arise.
Mr. Berry doesn't seem to have shown the court Lazarus Estates in Beasley.
No. And again, that would be an example of how it goes the other way, a case pointing in the opposite direction. So, my lord, I would say that Morris is distinguishable if the court is not in agreement with my submission, that it is also to be treated as separate from our kind of case because it is a prescribed notice in prescribed form. I appreciate what my Lord Justice Lewison says about the opening words of Lord Justice Mummery's judgment. That would be I would respectfully suggest, a further point of distinction. And I would also say the same about both Mountford and Stradbrook, which my learned friend took you to this morning. Both of those cases were cases in which information required by the Agricultural Holdings Act wasn't included in the relevant notice, which is again not the terrain that we are in. Those cases turned principally upon whether the notice given in a defective form nonetheless complied with the spirit and policy of the statute under which it was given. But that's not a consideration at play in this case, because there is no statutory or contractual validity requirement that is imposed for some policy reason. So the first category of cases are cases in which I say, therefore, this is the old Grovebury type cases, are simply cases where we are not in misnomer, we are in giving it to the wrong person or not enough of them. The second category are the Scottish cases, which I say are not about our problem either. The third category into which I would place Morris, but if that's not the category in which the court thinks it should go, I would distinguish in any event, are the Morris, Mountford and Stradbrook cases in which the statutory context in which the notices are given is important, and that is not a context that's at play here. And then the fourth category of cases, which deals, I think, with the balance of the authorities relevant to this particular issue, are cases in which the court anticipated the Manai test and decided it was not met, or applied Manai and decided the test was not met. So the first case of that category, there are four of them. The first case is the Cadby case, which is behind tab 4 of the bundle, and this is a case from the English reports before Manai was dreamt of.
A date case, isn't it?
It's a date case, exactly, and I don't think I need to do any more than refer you to the head note. It was simply not enough for the notice to say nothing more than, in this particular case, for this notice to say nothing more than this is served in accordance with the provisions of the lease, because there was no single date that could relate to. It was effectively an ambulatory date on the face of that notice. So that would be an instance of a court not so much refusing to correct a mistake, but not knowing what the correct answer would be once a mistake
is that right? I'm just looking at the head note.
Yeah.
This seems to contain a 21-year lease with a single break clause at the end of 14 years. The problem was 14 years from Michaelmas 1823 is Michaelmas 1837, and it's not given for Michaelmas 1837, but for the 24th of June, which I think is Midsummer's Day.
No, sorry, in that case I've got my note wrong. Can I come back to that, my lord? I'm sorry, I must have mistranscribed that in my notes to self. But I would also say that some of the other cases on actual misnomer rather than wrong date cases would be instances in which, again, the most easy way of understanding those cases is that they are cases in which Manai was simply not met. And the case that I would tackle under that basis is the decision at first instance of my Lord Justice Lewison, which is the Standard Life case. We considered the facts of that case this morning. The relevant facts, I would suggest, that explain why that case doesn't.
Sorry, just can we go back to Cabby and Martin?
Cabby, sorry.
I'm just looking at Lord Denman's judgment. as my Lord Justice Nugee points out, they've got the date wrong in his notice.
Yes.
The opinion of the jury, bottom of the page, was the plaintiff understood the notice to apply to the last day of the 14 years. And a verdict was entered for the defendant. Now, who's who in this case? Who's the plaintiff and who's defendant?
The plaintiff is landlord.
Plaintiff is landlord, right. So defendant wins. It's an action for rent, I think.
Yes.
So defendant wins because the landlord understood that the notice did what was the right day. And Lord Denman says the covenant to pay rent has not been got rid of, can't be got rid of by any notice to quit which is not in accordance with the proviso.
Yes.
So it didn't comply with the proviso. Cases that point the other way show that where there is no covenant, notice describing the premises so as to be perfectly understood between the parties will be sufficient.
Yes.
But in none has a proviso or covenant been held to be satisfied by a notice inconsistent with the terms of it. That's what they decide.
Yes. So that seems to be, I'm sorry, I've obviously misnoted that, but that's obviously getting towards the territory of what we would probably refer to as a blue paper, pink paper type situation, where a prescribed provision in a lease can lead to the invalidity of a notice, whereas the absence of such a provision may mean that such a notice is valid. And I suppose I could pray that in aid in my submissions as another instance of the sort of consideration that's at play in common law notices to quit, whereby where there is no prescription either. But I just wish to address, because a certain amount of time was spent on it, the decision in Standard Life and Linney. The aspect of Standard Life and Linney on which reliance is placed is the fact that a copy of a break notice which had been served on the incorrect person, which was the ultimate reversioner, had been provided to the agents for the right person, which was the intermediate leaseholder. And what my learned friend says is that that is something that assists him on his appeal, on the basis that it is an illustration of the fact that the simple fact that a notice coming to the attention of the right person through their agent is not enough. However, I hesitate to explain my Lord Justice Lewison's reasoning to himself, but there are a number of reasons given by my Lord Justice Lewison in that decision as to why the copy notice given to JLL was not, in fact, to be treated as a good notice. And that reasoning starts towards the end of paragraph 22 on page 140 of the law report. The first point that your lordship made was that there was no evidence that JLL had a decision-making power as agent in relation to that notice, and that there had been no evidence in relation to that. Whereas in this case, of course, the difference is that we know that as a matter of statute, Mr. Thomas does have that power because he is able to receive notices under Section 93 and the extended service provisions under Section 93 of the AHA. The second point that I suggest is relevant is at paragraph 23, that this was a copy notice. This was intended, as I read the judgment, to have been to inform JLL rather than to serve them with the notice. The third reason I discern from the judgment is that my Lord Justice Lewison in that case decides that there was nothing to say that JLL, holding a notice addressed to Capita rather than to Standard Life, wouldn't have been confused as everyone else. In other words, there was no certainty on the facts of this case about who the real recipient or the real named party was supposed to be.
Well, you skipped by saying that Morris applies.
But that, of course, that's the part that causes, that's where my learned friend, of course, then applies Morris. The difficulty with that, well, once again, we're in the territory, my lord, where I have to say that I would have to distinguish that, again, on the basis that our factual constellation is different. But I would also draw your attention to the fact that before your lordship gets to what your lordship describes to as the additional point, which is the Morris point, your lordship has already said, well, hang on, there's no evidence that they're the proper agent. There's no everyone seems to have been rather perplexed as to the effect of the imposition of an intermediate leasehold interest, and who's to say that JLL wouldn't have been as perplexed? So there was no basis for your lordship in that case, as I read it, to conclude that there was one obvious recipient on the facts of that case. So yes, for me, the uncomfortable reliance on Morris, I have to accept, but I would say, again, it's distinguishable because what we're hypothesizing is a different kind of reasonable recipient.
Well, you can always say I was wrong.
My lord, well, my lord, that would... my brave submission that Morris could be reappraised or could have been decided differently, it would follow that application of that decision which bound you in that particular case also falls with it. For present purposes, it's probably enough for me to simply say that Morris is a different world to the one that I'm in. So my lord, that's really where I get to on the main appeal. And essentially I say I follow the trusty roadmap of Lord Steyne to get myself into a territory where Manai can help me. And yes, there are different cases on different facts where different problems have been cured or not cured, but that doesn't illuminate the question of how the reasonable recipient would have responded to the notice in this case.
And if we're into Manai territory, I didn't really detect that Mr. Jordan very much criticised the judge's reasoning on why, if Manai if this kind of mistake is curable, it should be cured.
Yeah, yes.
His point was it's just not a curable mistake.
Well, yes. The reason for that is probably that once we're in Manai territory, it is, I would respectfully suggest, blindingly obvious what this document is and what it was supposed to do. And I therefore understand why the argument is instead we don't get into that territory and we don't get to solve the problem using Manai. But in my respectful submission, that approach rests on two, I'd respectfully say to my learned friend, fallacious bits of reasoning about Manai. The first one is that there are some unspecified category of errors that are simply outside the reach of Manai, which I think which I submit is not correct. And the second point is that somehow it is relevant what is going on in the mind of the giver of the notice, which I detect underlying certain parts of the argument in the skeleton argument. And I submit that's not correct either. Manai does potentially permeate everything. The limits to Manai are produced by the application of the test, and if it can be demonstrated that the reasonable recipient didn't know what was actually meant. That's the limit of Manai in my respectful submission. So that's where my submissions end on the appeal, unless I can assist further. I do have a respondent's... Sorry.
Well, there was just one point. Mr. Jordan showed us, both in Lord Steyne's speech and in Lord Hoffman's speech, bits of Manai which suggests that what you are trying to do is ask the question what the reasonable recipient would think the sender meant by the document that he sent. And that's not a question of looking at the sender's actual subjective intention. It's a question of how the reasonable recipient, circumstance as the actual recipient is, would understand the words used by the sender in that context. But if that's right, the fact that the landlord doesn't know that there's been an assignment, indeed as I understand it, doesn't even know the company exists, would lead the reasonable recipient to understand that what the sender was trying to do was send a notice to Mr. Thomas, not to the company. He clearly wasn't trying to send a notice to the company because he doesn't know about the company. So is Mr. Jordan wrong when he draws attention to those bits of manner? Has he misunderstood those bits of manner, or were they not significant?
I would never say Mr. Jordan is wrong.
I think you just heard. Well, fallacious.
but the inquiry is into what the reasonable recipient thinks the document is doing, and one gets to this rather slippery concept of how far do you focus in, and if one's focus is, well, this document is intended to bring the tenancy to an end, that is the function of this document, then the answer to your lordship's question is that really the identity of the tenant it is not the be-all and end-all of that inquiry. One looks at the function of the notice and tries to give effect to it. One tries to make sure that the notice is not a dead piece of paper. That is the concern of Manai within limits. So if the inquiry is what is the function of this document, rather than what do I think the landlord is intending to do, then if the function of the document is to bring the tenancy to an end, which is inherently what the notice to quit does, then the recipient of that notice would know that the landlord is intending to hit the conceptual target of the actual tenant at the time of the notice. In that sense, it's not really any different from the Manai type break notice misdating point. The tenant might think, tee-hee-hee, the landlord has put the 12th when he needs to put the 13th. And the landlord might say, if interviewed, yes, I put the 12th down because I just worked it out wrong, or I used last year's calendar, or I did whatever I did. But that's not relevant to what level of mistake occurs. What is relevant, I would suggest, is what the reasonable recipient thinks with the document in hand, and the authority referred to us by Lord Justice Lewison this morning, Lazarus, is clearly an example where a notice has been given to somebody else. Has been given in the name of another person, but the Court of Appeal, Lord Justice Denning and Lord Justice Morris, say that it is blindingly obvious, given that the notice refers to the tenant, that the notice is meant to be the person answering that description. That's a very long-winded way of answering that question, my lord, but it depends how wide or narrow one wants to draw the focus, and in my submission, the focus is determined by the function of the document. And the document here only has a function if aimed at the tenant.
I think what I understand you to be saying is, yes, you do look at what the reasonable recipient would understand the author of a document to be doing. What the reasonable recipient would understand the author of a document to be doing in a case like this is seeking to serve notice to quit on the tenant, whoever that might be,
yes,
and thereby bring the tenancy to an end.
Yes. Now, in some cases, I would be sunk, because in some cases, because the assignment might have happened to a totally independent third party, this argument simply wouldn't be available. But on the present factual constellation, that argument is available.
I see.
Yeah, if you go back to Lord Steyn at 772, page 174, between G and H, it says the question is not whether 12th of January can mean the 13th of January, it self-evidently cannot. The real question is a different one. Does the notice construed against this contextual setting unambiguously inform a reasonable recipient how and when the notice is to operate under the right reserved?
So it's a functional question, if you like. And that follows on, my lord, from the endorsement of Mr. Justice Goulding's formulation in Caradine. Is the notice quite clear to a reasonable tenant reading it? Is it plain that he cannot be misled by it? Well, the reasonable tenant here, knowing what he knows and instanced as he is, cannot have been. There is then a point which there are then some points taken in the respondent's notice which I'd like to address the court upon, and they are essentially fourfold. They are to do with the effect on this notice of A, the common law provisions relating to service, and then B, on section 93 of the Agricultural Holdings Act. Essentially, as a sort of spoiler, I think the difference between my learned friend and I on that is my learned friend says, well, if your notice is invalid, it doesn't matter that you've got a extended service provision because what you've served is an invalid notice. That's the argument I face on section 93. My answer to that, and I'll take this briefly if I may, but my answer to that and the basis of the respondent's notice is that the court below could have decided this case on the following basis. Building on Townsend again, there was no need for there to be a specification of a name of the tenant. The tenant could have been identified generically. Therefore, the identification of the name of the tenant is innocuous. And if one then looks at section 93, which is in the bundle behind behind tab 26. No, I'm so sorry, it's behind tab 25 and it's section 92, service of notices.
No,
right at
that's the 48 Act.
Oh, is it? Sorry.
You do want tab 26,
yeah.
Page 374.
Yes, that's it.
Is 1986 Act.
The effect of that is that the notice would be valid at common law because it doesn't need to identify any particular tenant. And but in combination with section 93, an extended provision is made for the service of notices. And I would draw the court's attention, please, to sections 93, 2 and 3.
It's a curiously worded section.
Yes.
Because it starts by saying any notice, etc., shall be duly given to or served on the person to whom it is to be given.
Yeah.
Now, we're dealing with a notice which has to be given to the tenant.
Yes.
And let us take, for argument's sake, what we know, the tenant is the company.
Yes.
And then 93.2 says, any such instrument, i.e. a notice, shall be duly given to or served on a company if it is given to the secretary or clerk. So on the face of it, leave aside Jones and Lewis for the moment, on the face of it, it's dealing with two things. Not only is it dealing with a service of the notice, it's dealing with a giving of the notice. Yes. But that doesn't seem to be how this court has interpreted it.
No.
Although the court was looking at the equivalent section in the 48 Act, but as far as I can see, it was exactly the same.
Yes.
Exactly the same words.
Yes, it was. But again, one also looks at 93.3. Any such instrument to be given or served on a landlord or tenant shall, where an agent or servant is responsible for the control of the management or farming, as the case may be of the agricultural, and be duly given or served, if given or served, on the agent or servant. So it becomes even more circular. It becomes slightly circular in 93.3. But what it is an agreed fact that it is that the person who has the everyday running and control of the agricultural business is Mr. Thomas, and that he is a person satisfying section 93.3, so that I would pray and aid those provisions insofar as any issue about given, by indicating that either under section 93.2 or 93.3, the requirements of the statute as to how a notice is to be given have been satisfied.
(93.5) is interesting. That enables the tenant to serve the landlord if he doesn't know of an assignment or reversion. There's no equivalent in the case of a tenant, is there?
No, there isn't.
Well, it is a curiosity of the common law that you can end up in privity of the estate with somebody you don't know about.
Yes, I mean, in most cases, that's of course been dealt with just simply by covenants about alienation and contractual provisions. But it's the curious consequence of the fact that the lease, at least HHJ Lord Hoffman, gives rise to an estate in land and an interest in land which is freely assignable unless restricted by some provision to the contrary.
Why do you say HHJ Lord Hoffman?
Lord Hoffman, in a case called Bruton and London Quadrant Housing Association, decided that a lease could exist which was not an estate in land.
I don't think that's what he did decide, Mr. Radley.
Well, I hope not.
He decided that a lease could create an estate in land which bound nobody but the landlord and the tenant. In the same way that a squatter requires a freehold title, but it's not good against anybody.
It's taken up a lot of trees and a lot of journals.
It has, and it's a widely misunderstood case.
My lord, could I ask those behind me if there's anything else?
I just returning to section 93. As I understand it, it is possible, though no doubt very unlikely, to give notice to quit an agricultural holding orally.
Yes.
In which case nothing is being, quote, served, unquote. And I did wonder whether that is why section 93 includes the word given.
Yes. Yes, that may be a way in which it's given. It has meaning, particularly if it copies over older statutory formulae where maybe a written notice to quit might have been a less common practice. It may simply be a copy and paste of a statute devised in different circumstances with different customs.
Yeah, well, it's clearly a copy and paste from the 48 Act, but where the provenance of that comes from, I don't know.
My lord, if I can just take instructions. My lord, I've got nothing further to add.
I'm just looking at your respondent's notice. You've got 4 separate points, including that it comes within 93.1 on the basis it's left at the company's proper address. So it's your submission that if it hadn't been addressed to Mr. Thomas, it had been addressed to Mr. Barnby, but left at the company's registered office, that would be good notice under section 93.1.
On that argument, yes. On that argument, it would simply be the notice has been given and the requirements of 93.1 have been complied with. But I would suggest that one looks more at 93.2 and 3.
I'm going to say that I'm not sure if you don't get home on 93.2 or 3, you're unlikely to get home on 93.1. And if you do get home on 93.2 or 3, you don't need 93.1. I just wondered how realistic the suggestion was that you don't need to put any name. It doesn't matter what name you put in,
yes,
as long as you leave it at the right place.
Well, my lord, I'll push it no further.
Yes, I see. Thank you.
Mr. Jordan.
Going back to this morning, my Lord Justice Lewison drew a distinction which I would repeat between the concept of addressing a notice. Who are you telling to quit? Serving a notice, which is bringing it to the attention of the person whose attention it needs to be brought to, or if one is using section 93, there are deeming provisions which deem it to be brought to the attention. And then the contents of the notice. In the case of a notice to quit, does it give the right date? Does it say leave the land on the right date? And those are 3 distinct questions that can arise about a notice.
So
Who
have you addressed it to? Who have you served it on? And what does it say?
Yes. And we have agreed that the notice was served on the company. It was read by the controlling mind and will of the company. There's no question that the company knew what the document said, and that has never been an issue. Nor is there any issue about context. This is all about addressing. And the word giving is one which I think, although it's widely used in the context of notice, it's unfortunately ambiguous. If I write a letter addressed to my learned junior, Mr. Benison, and I put it in the hands of my learned friend, Mr. Radley Gardner, I have given him a piece of paper, but I haven't given him a letter because the letter is for Mr. Benison. If I give it to Mr. Benison, it's both been delivered to, served on Mr. Benison, and addressed to Mr. Benison. So my learned friend said that we had accepted that the notice was given to the company. Well, we've accepted it was served on, delivered to, received by, read and understood by the company. But what we don't accept is that it was addressed to the company.
So you say a notice cannot be given to the tenant within the meaning of section 26 unless it is addressed to and served on the tenant.
Yes, and it can be addressed to
Or at
the
least
tenant.
addressed to and brought to the tenant's attention.
Yes.
Well, you might be able to advertise it, I suppose, in a local newspaper or something like that.
Well, there needs to be something done by the landlord that causes the tenant to know about it. That's what's meant by service.
Yeah.
And section 93 provides convenient methods for making sure it's done and identifying the precise date when it's done. The Scottish cases were not about delivery. They were not about service. They were about addressing. And I won't go through them all again. I'm sure the court will look at them again when preparing the judgments. But if I can just show one paragraph in Ben Cloyd to make the point good. Tab 3, page 46, paragraph 62.
60, isn't it, when he says that?
60, a notice address. 62 shows that the court was concerned to consider what the document said in order to decide who it was addressed to. It wasn't. It had landed in the right registered office. It had been read by the director of the right company. There was no service issue. Couldn't be any service issue. It was all about addressing. And what the Scottish court, what the Inner House meant by saying that tenants must give the landlords written notice is that the court recognised that in some situations you wouldn't have to use a name, but if you do use a name, then that is who you're giving the notice to. And that's even clearer in the Balgray case, where there was no. The Balgray case, it was said in terms several times. There are no provisions about service. There are no requirements about service in the statute. There's no requirements about the form of the notice. It can be oral. But the fact is, if you choose to put a name on it, and you choose to send it to a specific individual, then that is who it is given to. And the mere fact that that individual is also the controlling mind of the person who the notice should have been addressed to doesn't make it a notice given to the landlord. My learned friend said that because it's unnecessary to include a name, that the inclusion of the name can't invalidate the notice. But I attempted to deal with that point in my opening. It doesn't. The one doesn't follow from the other. Once you choose to include information, even if you weren't required to do it, then who the notice is addressed to is considered by reference to the information. That's clear from Balgray. A point in relation to what knowledge should be attributed to a reasonable person in Mr. Thomas's position. I made a submission that it was by no means obvious, except to a property lawyer, that in a situation like this, the notice must, if it is to be effective, be addressed to the current tenant rather than the original tenant. My learned friend said, well, one must attribute to Mr. Thomas at least enough sophistication to know that a company is a different person to an individual. That is a quite different level of legal knowledge. In my submission, everybody knows that companies have different identities to individuals. One experiences companies every day of the week. But the question of to whom a notice to quit should be served, where an oral tenancy has been assigned by the original tenant to somebody else, a company that he's incorporated, is not in that category of legal knowledge. It's not something that one can attribute in a straightforward way to a farmer.
Do you emphasise, do you place reliance on the fact that Mr. Thomas and the company are two extant different legal persons? Would it be different if one of them didn't exist? If the addressee of the notice didn't exist.
So if a notice had been addressed to a company that wasn't registered a company.
OG Thomas Limited, without the agriculture bit, for instance.
If it had been addressed to OG Thomas Limited, then that would be I would suggest a Bricklayers Arms type situation, or a Walter as opposed to, I'm not going to try and pronounce the...
Yeah,
that is love, I think.
But it would be a case where the name was clearly an attempt to identify the right person. It's just something that got mangled in the language used to do that identification.
But that would be another step. You'd first have to use Manai to take one back, or principles akin to Manai, to take one back to what one would assume had been meant in relation to the name of the company. But then you would still say, then you get the correct name of the company, but the notice is addressed in a way that means it falls foul.
Yes, in a case where the language used is a Mary when you clearly mean James sort of situation, then Manai does apply to the addressing of a notice.
Yeah, I'm just curious about how that fits in with what Lord Hoffman said in Manai. Going back to tab 14, at page 776 in the report, 178 in our bundle, he refers to the Waterman's Arms, Bricklayers Arms case and asks what's the principle. Then he refers to Peel, and then he goes to Fish on page 777. Testator leaves his residuary estate to his niece Eliza. He had no niece called Eliza, but his wife had an illegitimate grandniece called Eliza, who he must have intended to refer, and a legitimate grandniece called Eliza. The Court of Appeal said the estate went to the grandniece. And he says at C, he quotes Lord Justice Lindley, and then says, if there was no one to whom the description accurately applied, there was said to be a latent ambiguity and evidence of background facts showing what the testator must have meant, and evidence was admitted. And then he gives his comparison. See you at the festival hall on the 12th. And he says, according to the old rules, the law will agree that if there's no concert at the festival hall on the 12th, in that case there is a latent ambiguity, but if there is a concert on that date, he will be taken to refer to that concert. And he clearly rejects that. So the fact that there are two extant persons, one legal, one natural, doesn't seem to be a relevant point if you're trying to apply Manai.
Lord Hoffman's theme is that the principles that apply to the interpretation of communications in ordinary everyday affairs should be applied to the interpretation of notices. And the old rule that produced results quite inconsistent with that should be rejected. That is his theme in this part of his speech. And an ordinary common sense interpretation of the notice is it's saying to Mr. Thomas, you are the tenant of the farm and you need to vacate it on this date. And yes, Mr. Benison reminds me that at the top of page 176 at letter B, Lord Hoffman said he must use words which unambiguously convey a particular meaning, namely an intention to terminate the lease on 13th January.
Yeah. And
if it is apparent, as in the festival hall example, both parties know which concert they are going to. You can't possibly be intending to refer to a concert that neither of them has ever expressed any interest in going to. So, my submission that approach of Lord Hoffman if applied in a case like this, produces only one answer, which is that the notice was addressed to Mr. Thomas and would have been understood by a reasonable recipient as addressed to Mr. Thomas. There was absolutely no reason to suppose, or put it another way, it can't mean one thing if you read it in Mr. Owen's office when he's written it out and is about to put it in the envelope, and mean something else when it gets to Mr. Thomas, because of something that Mr. Thomas knows, Mr. Owen doesn't know. The Lazarus case I need to address. This was a case where, as explained by Lord Justice Morris, there was a tenant of a property, Mr. E.C. Beasley, and he died, and his widow, Mrs. Violet Beasley, became a statutory tenant under the Rent Act. And the notice referred to the tenant as being Mr. E.G. Brassley. And what Lord Justice Morris says, whereas she was the tenant as a successor to her late husband, did not in any way mislead her. She appreciated that the name had been wrongly inserted and wrongly spelt, and she must have understood that notice was being given to her as tenant of number 13. And the other two judgments were to the same effect. So there are 2 points. One is that the court was clearly applying a subjective approach, which is no longer the law. But more importantly, it was a Walter type case where everything was right about the name, except the Mr. and the initials and a misspelling of Beasley instead of Brassley.
Well, except that it was addressed to her late husband. On your analysis of these cases, you identified the wrong person. Somebody who had been a tenant, but no longer was, and moreover was dead.
Well, in my submission, this is a case where the relevant facts were known to both parties. It's not like this one where the key fact that the judges below relied on was known only to the recipient and not to
We don't know, do we, what the landlord knew? Doesn't seem to be relevant. They got the recipient of the notice wrong, but it didn't matter.
Certainly the surname was very close to being right. And the fact that Mr. instead of Mrs. was put in was a true case of a misnomer.
The gender was wrong, the initials were wrong, and the surname was wrong. And there was somebody who approximated to that name, but he was the tenant and no longer was.
Well, it wasn't correctly identifying her late husband, and it wasn't correctly identifying her. But it was treated by the courts as being a case where, reading the notice, it was plainly intended to identify her. That was indeed understood by her as identifying her. But to the extent that it is to be treated as taking a different approach to the cases which we rely on, we submit that the cases we rely on were correctly decided, and there are a number of them. To the extent that this case is authority for some wider, looser approach, then it was wrong. But my submission, it was correctly decided, applying the principles that we say ought to be applied.
It was also addressed to the tenant.
Yes. I wanted to pick up a suggestion made by my Lord Justice Lewison, which I believe my friend adopted, which is that given that the notice in our case said that Mr. Thomas was the tenant of the farm, you could reject his name as falsa demonstratio. Just to say that in all of the cases I rely on, the notice did make it clear that it was addressed to the landlord or the tenant, as the case may be. So if that analysis was right, it would have applied in Morris and Standard Life, and Balgray and Ben Clorish. In each case, the notice made it clear. There's some discussion in paragraph 62 in Ben Cloyk about the fact that it said that Bonnie Toon was the landlord. So if that analysis was the right analysis, those 4 cases would all have had to be decided differently. My learned friend drew attention to the Harmon case, which I didn't look at, which is at tab 9, page 76. And one can see immediately from the catchwords at the top what it was about: agency, authority, general agent. This was a case of a general agency, as was the Townsend case. It was a case where Mr. Harvey acted throughout as the landlord. So neither that case nor the Townsend case are of any relevance here, where there's never been any suggestion of a general agency. In the Townsend's case, in a passage that my learned friend showed the court, Sir Robert McGarry, Vice-Chancellor, discussed obiter, the question of whether there was a difference between addressing a notice and giving a notice, and inclined without deciding to the idea that there wasn't really, providing the substance of the information reached the right mind, it should be treated as given. He didn't decide the point, and he was wrong with respect. It's clear from the cases I relied on that it's not enough in these kinds of cases. There needs to be clarity. One needs to have a specific date when the notice is given, and that is the date when the notice addressed to the right person is served on the right person or deemed served.
Specific date?
Yes, in these cases it is necessary to identify a date, because the 1 month for giving the counter notice runs from the date of giving of the notice.
Yeah. Not well. Part of what Sir Robert said was approved by the Supreme Court in a case called UKI Kingsway and Westminster as about a completion notice for rating purposes, and they approved what Sir Robert had said about indirect service, which does not sit with your submission that there has to be a specific date. They recognise that there might be uncertainty about the date on which the notice was served. They didn't, I might say, they didn't approve the particular bit when he drew the distinction between addressing and giving, but they did approve a section of that part of his obiter remarks.
Well, in that case, I will withdraw that last submission, but it doesn't affect the rest of my argument.
Yeah.
The fundamental point is that there is a difference between giving, addressing, and serving. My learned friend dealt with the Mountford and Earl of Stradbroke and Mitchell cases by saying that they turned on statutory context, but they can't be explained away in that case, I suggest, because whatever the sources of the requirement or opportunity, right to serve a notice, one comes back to the question of who must it be addressed to, how must it be served, and what must it say. It doesn't matter whether the source of those requirements is a statute or a contract. The courts have made that clear. And if there were any doubt about it, it's resolved in Pease and Carter. But certainly in those cases, the Court of Appeal in the first one and Mr. Justice Alderson in the second one applied precisely the same approach that the House of Lords later said in Manai ought to be applied to a contractual notice. There wasn't anything in the judgments that suggested it was the statutory source of the notice that made any difference to the analysis, and it doesn't. The Cadby case, which I hadn't looked at tab 4, I would suggest doesn't really assist very much. One looks at page 59. Lord Denman said it was submitted that the error of this notice in point of time was cured by the plaintiff's conduct, who had written on the 27th of November to acknowledge the receipt of the defendant's letter dated the 1st. A long time after, he told the defendant that he perceived the defect in the notice, but it was no business of his to point it out. The opinion of the jury was that the plaintiff understood the notice, despite the last day of the 14 years, and a verdict was entered for the defendant. So it seems to have been common ground that the notice was erroneous in point of time. The only question was whether the fact that the landlord knew that and kept quiet about it should affect the outcome, and the court said it shouldn't. My learned friend referred to one paragraph in the Linney case, but I didn't show the court. I could go to tab 20 again. First of all, to page 287, paragraph 4.
Yeah.
Clause 1.8.
That was what paragraph 22 was all about.
Yes, exactly. So paragraph 22 was dealing with a different argument, not relevant here. My Lord Justice Lewison said that I had effectively accepted that if the mistake in this case was curable under Manai, then it should be treated as cured. I suggest it does go back to the question of at what level you ask the question. If it is very much a case where the right question leads to the right answer, if the right question is, would somebody reading the notice have realised that the landlord was trying to give notice to quit, then yes, that is what you would appreciate the notice said. If the question is, would the reader appreciate that the notice was intended to be addressed to whoever might happen to be the tenant, then I would submit the answer is plainly no. And if the question is, would the reasonable reader have appreciated it was intended to be addressed to the company, then again the answer is no. And the right question in my submission is, to whom was the notice addressed? What would a reasonable reader understood the words in the notice to mean? And they would understand it to mean that Mr. Thomas, as tenant of the holding, was required to vacate it on a specific date. On a specific date. So those are the points I wanted to make by way of reply on my appeal. So that just leaves the respondent's notice. The starting point here is that His Honour Judge Jarman dealt with this as the first point in his judgment, and we say he was right. So if I could ask the court to go to what he said at tab 15 of the appeal bundle. It's not page 160. At paragraph 8, he says, the 1986 contains several references to notice to quit, but not a requirement that such notice must be addressed to the tenant in writing. The ways in which notice should be served is dealt with in section 93, which he then quotes. And then at paragraph 9, he quotes from Scammell, Densham and Williams, which says the effect of section 93(3) is that service on an agent is due service, providing the agent was authorised to receive such notice on behalf of his principal. The person responsible for the control of the management of farming, as the case may be, the agricultural holding, is deemed to be the agent for the tenant. In contrast to the common law position, there's no need for agent or servant to be authorised to receive the notices being served. So certainly the author of that textbook interprets section 93(3) as being concerned with deeming agency for the purpose of service of the notice and having nothing to do with the content of the notice. Paragraph 10, the learned judge drew attention to section 93(5), and the fact that there's no corresponding provision where there's been a change in the identity of the tenant. And another textbook is referred to in paragraph 11, Muir, Watt and Moss on the law of agricultural holdings. If a tenant assigns his tenancy, then even if the landlord has no notice of the assignment, it would appear that service on the original tenant would not be good service. And then at page 164, at paragraph 20, the argument on behalf of the claimants is recorded. Relying on section 93.2 and 93.3. And that is then dealt with at paragraph 24. Section 93 focuses on the latter issue, the issue of service, and sets out what is or may be deemed to be good service in different situations. And then he goes on to deal with the interpretation point. So this point was argued at first instance and decided in my client's favour, and rightly so in my submission. We can go back to the authorities bundle. To section 93. On page 374.
The point wasn't dealt with by Mr. Justice Zacaroli.
No, it was argued, but Mr. Justice Zacaroli, having decided the interpretation point, didn't need to decide it.
Yep.
It only needs to be decided if the interpretation point is decided in our favour.
Yes.
So the first point to notice about section 93 is that it's headed service of notices. So unlikely, one would think, to be concerned with the content rather than the delivery. My Lord Justice Lewison has drawn attention to the fact that the word given and served are both used in it. That is, as I think was also suggested, explicable by reference to the archaeology of the statute, because there were a whole series of agricultural holding statutes starting from like the 1870s, and the 1948 Act, and there were previous consolidation acts as well, but 1948 and then the 1986 Act consolidated them. So it's not surprising that there are a variety of different expressions that need to be picked up in a service provision like this. Indeed, in section 26 itself, on page 369, in A, it says notice to quit an agricultural holding or part is given to the tenant, and in B, it says not later than 1 month from the giving of the notice to quit, the tenant serves on the landlord a counter notice. So my submission, those expressions in subsections 1, 2 and 3, given to or served, are just there for the avoidance of doubt, no matter how the language is, whatever language is used in the various sections under which notices can be served. These service provisions are to apply.
And the same wording was used in section 92 in the 1948 Act, given to or served on.
Yes, section 92 of the 1948 Act is on page 361.
Yes.
And as far as I can see, the only differences are that subsection 1 didn't refer to recorded delivery service, which I think came in later than 1948. And in subsections 2 and 3, I think it's just the words "as aforesaid" that have been removed in the 1986 Act. But apart from that, the two provisions are identical. We've drawn attention to the problem, the mischief that we suggest that section 93 is directed at. It's the mischief of working out whether somebody does or doesn't have authority to receive a notice. And we've cited Bousted on agency at tab 28, page 380, and the principle at Article 94 is a notification given to an agent is effective as such if the agent receives it within the scope of the agent's actual or apparent authority, whether or not it's subsequently transmitted to the principal. unless the person seeking to charge the principal with notice knew that the agent intended to conceal the notification from the principal. One can see if one's trying to rely on that, it's going to give rise to all sorts of problems. And indeed, the illustrations on the next page, on page 381, illustrate the various outcomes. I could just ask the court to skim read illustrations 1 to 4.
Yes.
So what section 93 is doing is saying, subsections 2 and 3 are saying certain persons will be treated as having statutory authority to receive notices, and then it won't be necessary to inquire into these sorts of issues. And if there were any doubt about the matter, we say it is resolved by Jones and Lewis, which is tab 11. As the court has seen, I think, this was a case where there were 2 tenants of an agricultural holding. One of them, Henry, lived in the farmhouse, and Emily lived elsewhere. And a notice was served under section 24(2)(d of the 1948 Act to remedy a breach of covenant. And only the name of one of the tenants, Henry, was inserted in it. And the court said that that was insufficient, since the tenant were 2 people and only one of them had been named. And the relevant part is on page 96, the part sidelined in green. Mr. Hewson drew attention to section 92(3) of the Act of 1948. It provides that a notice can be served on an agent, whether as one who is responsible for the control of the management or the farming. But I do not think that's of any assistance. It's only dealing with the service of the form. It does not deal with the contents of it.
Lord Steyn might say that's conclusionary rather than reasoning.
Well, my lord, that may be so, and it may be if we're in the Supreme Court, my learned friend could have a go at the conclusionary reasoning and conduct what Lord Steyn called a gruesome autopsy into it. But in my submission, it is right, even though it's briefly expressed. It's plainly right.
It's what this court decided.
Yes.
The predecessor of this section was about.
Yes. So in my submission, if the court determines that our ground of appeal is correct, and the notice can't be interpreted as a notice to the company, it should be interpreted as a notice addressed to Mr. Thomas, then section 93 doesn't help the respondents. Can I just check if there's anything else I need to cover?
Thank you, Mr. Jordan. Well, thank you both very much for your very interesting arguments. As it won't surprise you to learn, we will reserve our judgment. You will get draft judgments in the usual way electronically. They will be sent to those whose email addresses have been provided to my clerk. The draft judgment will come with a very fierce embargo, which means exactly what it says. Any breach of the embargo may be treated as a contempt of court. Your instructing solicitors will be responsible for the proper distribution of the judgment to those who are entitled to receive it under the terms of the embargo. When you have the draft judgment, please make any typographical corrections, preferably by agreed list, and if you can, please agree a form of order disposing of the appeal. If you can't agree a form of order, then make short submissions in writing, and we will make the order that we consider to be appropriate.
One short point, my lord. My client has a land agent who provides instructions. He's not the client, but he gives instructions on behalf of the client. Might the draft judgment be shown to the land agent as well as to the client?
Is the land agent, so to speak, giving Mr. Williams direct instructions on behalf of the company and or Mr. Thomas?
An accountant and a land agent jointly instruct Mr. Williams.
I don't want to broaden the circle too widely.
No, I understand. That's why I'm asking.
Yes, the land agent can see it, but no further. And obviously on the terms of the embargo.
Of course.
Thank you very much.